I think it's fair to say Jon is the undisputed master of open records, open meetings, and defamation litigation in Kentucky. Every major case you read in those areas has his name on it, right at the top. He's argued countless cases in trial courts and in appellate courts across this state and in federal courts, establishing law for the press and the citizens, right, to know what their government is up to. Jon has won every single award this organization gives out. I'm pretty confident. In fact, they now have an award named after him. And he's won pretty much every other press or First Amendment Freedom Award in this state, member of the Kentucky Journalism Hall of Fame. And it's all well-deserved. So it is truly my pleasure to be here today to introduce my colleague and my mentor and my friend, Jon Fleischaker. So I'm here to play traffic cop today. So I'm going to ask a few questions, Jon. So let's go back to the before times. It's the early 70s. You're a young lawyer. You just came from the Supreme Court in the Brandsburg case. How did we wind up in the General Assembly talking about the open meetings law?
I came back from the Supreme Court, and the next day I was in police court in Kentucky. So I think what happened, and I'm comfortable what happened, with the early 70s was a time of real change and activism in the United States. We had Vietnam War going on. We had the Pentagon Papers case, which was a 1971 case, I believe. We had a rebirth and a very strong civil rights era that was ongoing. And we had a situation where there was great distrust about government and government officials. And Watergate. Watergate was also going on at that point in time, a little bit later, but still in the 73, 74 time period. The KPA at that point was the Bingham family was very important in maintaining and encouraging the KPA, and the decision was made to try to start what was then going around the country, that is open meetings and open records under different names. The decision was made in '73 to start with open meetings with the idea that it would be easier to pass. There were a lot of reporters, and I can think of a couple by name, who really were against open records at that point. They thought that good reporters could get anything they wanted. They didn't need to have a law, and that this would shut off sources. They were wrong. They were wrong on all counts. But we got the commitment, the Binghams, I believe, got the commitment from the governor, who I think was Governor Ford at that point. And we started drafting. Now, this was 1973. I was a very experienced 27 or 28-year-old lawyer who really didn't know what he was doing, but I knew enough to start looking at the books and seeing what was on what other states had. And we put together the open meetings law, which was opposed, as were the open records laws, by two main forces. One, we always had opposition, and still do, from law enforcement and from people who administer law enforcement agencies. The second one, which really has surprised me for 50 years, is the opposition to transparency that is exhibited by most universities and colleges in this state, and as I understand it, throughout the country. The biggest opponent to transparency has always been colleges and universities. That has always surprised me, and it has turned out to be a great source of litigation, which I've enjoyed. Telling university presidents, no, I'm telling you what to do, you can't tell me what to do. That is, depending on which end of the table you're sitting on, either a great thing that I have or not a very good trait. So it really was part of the whole idea, Mike, that we were moving into a new era, and we really got started. We didn't know what we were doing, but we tried hard, and I'll get to it later, but we, after 15, 16, 17 years of working on it, we come up to 1990, and ended up by a circuitous route with an interim committee of the General Assembly to review it, and the result was that we strengthened the laws substantially. But we can get to that later.
Yep, we will definitely get to that. So I'm struck some things never changed. We still have quite a bit of resistance from law enforcement and universities to a lot of stuff we do. But what was it like to actually go before a General Assembly that was open to transparency measures? I find that kind of hard to fathom sitting here today.
It probably would be hard to fathom, except in those days the governor dictated what was going to happen. I don't want to say it was the good old days, but when it came to that kind of stuff, it was the good old days. I'm not sure we could have gotten it passed. I know we couldn't get it passed in the current legislative environment. But Ford was a big fan of it and had committed to it. And we had the same kind of commitment from the next governor, Julian Carroll. And we had, so it really wasn't a problem at the legislative area. The problem was some of the negotiation that took place prior to that, but we got it done. We had much more negotiation, frankly, on the open records law with the state police and law enforcement really coming down hard on us. But we did something in the 70s that simply couldn't be done today, in my judgment.
Yeah. So let's talk a little bit about the original version of that law. Some of the key features that you all put in the original version were, the requirements of the minutes, schedules of regular meetings being published, the executive session procedures and the limitations on that, special meeting rules, and, some of the initial penalties that were in the act. Why did you think, when you were looking at it, why were those the areas you focused on? And maybe were there some things you all tried to get you couldn't get at the time?
I think there were two areas, there really were three areas that we should have focused on. One was the definition of a public agency. We didn't focus on that as much as we should have. A lot of correction went into in the 1990 situation on the definition of public agencies. The procedures, I think, are extraordinarily important, and nobody had them, nobody knew what to do with them. Nobody raised a question about it because they frankly didn't read it probably. They still aren't reading it. So we have, I think my judgment is that the procedures were an immensely important thing, and I think you would agree, Mike, that as we litigate this stuff, the procedures really have been a winning point on a lot of cases. As most of you know, when you run into public officials, they often take the position that it's their government, not your government. It's their, they can do what they want to do. What I find really interesting is the more things change, the more they stay the same. Mike has ongoing litigation now dealing with so-called private cell phones and the use of cell phones to do text messaging and emails during meetings or in lieu of meetings. If you look at the definition of a public record, and this goes to records, in 1974, or 75 when that was drafted, it includes, in my judgment, cell phones. It includes electronic communication. Either the person who drafted it was extremely brilliant in including that. Most likely, in fact, the truth is, it was just plain luck. Because what we did was to take a variety of statutes and try to put them together. I had a partner in crime on the open records, and I know we're not supposed to be talking about open records, but he was also very involved in the open meetings, and that is a guy named Bill Cox. one of my favorite people. Bill has been dead for coming on to 30 years now, more than 30 years. But he was a terrific reporter, a terrific editor. When we were negotiating the penalties, we were sitting at the table and going around the table about how do you penalize, both for open meetings and open records, how do you penalize them? You know, fines, penalties. And Bill, with a very straight face, said, it should be the death penalty. He said it with a very, I mean, he had a very weird sense of humor, but the more I practiced in this area, the wiser I think he seems.
Guessing the governor didn't go for that back then, so.
Well, we would exempt certain people,
Yeah.
and they would go with the rest.
Yeah. So we will get back around to the ways that agencies use technology to circumvent meetings laws today, because you're right, there's a lot of that going on. But let's go back to some of the old-fashioned ways of circumventing the meetings requirements. So you had a case with the Jefferson County Fiscal Court immediately after the law went into effect. Tell us about that case.
We talked about the procedures. I assume most of you know about the procedures to go into a closed meeting, to notify regular sessions, what you can go to a closed meeting for. And I got a call from the reporter. The four members of the fiscal court of Jefferson County were meeting at the Louisville Boat Club at lunch. And they were clearly going to talk about business, and I said, the reporter said, what should I do? I said, go invite yourself to the meeting. So he walked into the boat club and sat down. It shook them. They didn't think that the reporter should be there, so they adjourned the meeting, got on a boat, the four of them, and went out into the middle of the Ohio River to talk about public business. We won that case. I actually argued that case against a former attorney general who was a partner in a major law firm, and that's the first case I argued at the Court of Appeals. Had a second case, very close to that, the same time period, against the Jefferson County School Board. Jefferson County School Board was represented by an attorney who I did really like. His name is Preston Young, was Preston Young. Very nice person. Bill Cox always said that he always hoped that everybody we sued was going to be represented by Preston Young, because he was not the best lawyer in this situation. So we sued the Jefferson County School Board for some things that were going on in closed session. And I called Preston and said, I want to take the deposition of each of the members of the school board. And he said, why? I said, to find out what they talked about, Preston. And he said, well, you don't have to do that. I'll just give you the tape recording. Well, the tape recording worked very well. We won that case. So for the first two, I was 2-0. And what was even more important was that the public agencies, both in Louisville and Jefferson County, but around the state, started to understand that there were consequences to violating the law, and that there were people out there who would hold their feet to the fire.
Mm-hmm. So let's fast forward a little bit. So, the law is being implemented. Agencies are starting to realize they have to follow it. But, it wasn't perfect, right? You already alluded to some changes that happened in the early 90s. First, why don't you talk about how that process came about, and then we can go through some of the specific changes in a minute.
The hero of this process is David Thompson, and he really is a hero. We had a couple cases that really created some problems for elected officials. David will remember names that I don't remember, but in the 1990 legislative session of the General Assembly, there were some very severe proposals to rewrite the open meetings and open records laws because the legislators were a little ticked off at some of the results we were getting. David said, don't rewrite it, create an interim committee that can meet and will report back for the 92 session. And on that committee, he suggested that the press association, the Kentucky press, should be represented by 3 people. I was one. Stan McDonald from the Courier-Journal, a great reporter and great editor, was one. And Steve Lowry was one. For those of you who don't know or don't remember Steve Lowry, he was a great journalist. He was a super journalist from out in the state. He had a terrific run. He was a great friend of Kim's and mine, and we miss him. We miss him in his good days because he was terrific. So the 3 of us would meet, and there was some hostility in the room, and we were meeting with a bunch of legislators, and we'd go through the provisions of each law, and they'd say why, or are you having trouble with this? And we had firsthand information from Lowry, from McDonald, from me, talking about how we weren't able to get this or we weren't able to get that. One example in the open meetings law was the definition did not include joint agency planning commissions that might be there for 2 or 3 different counties, or health commissions. So we put in a much broader definition, and by the time we got to the end of the process, we were getting suggestions from the others in the committee on how to make it stronger. We probably met 6 or 7 times. We met in the Capitol, and we had 2 of the best newspaper people I had ever worked with involved in this exercise. One of the things I said to Mike, I mean, one of the big cases that we've won under open meetings and open records was the University of Louisville Foundation case. I don't think we would have won that case under the old definitions. But we broadened the definition so that it clearly included universities and related entities that might be formed. And we're still having trouble, by the way, with certain universities, including one that is fairly locally located, that believe that they can outsmart, that they can create a new entity and get around the law. I think they're mistaken, but it's an ongoing problem. We continue to see, it's really pretty interesting, we continue to see things now where new people are coming in and they think they have found a way. And Michael and I'll talk, and Michael will say, what's this? And I said, well, I had a case like that. They brought it up in 1978, or they brought it up in 1984. There's really nothing new under the sun. It's just a matter of trying to confront. And we've been very successful doing that.
I would say one of the top lessons I've learned from my partnership with Jon, and there are many, but we can't stop fighting the battles we've already won, that you've already won, and the folks in this room. It's amazing, because you get new folks on the other side who come up with the same arguments and try them over and over and over again.
That's true, but we have an advantage. I have an advantage, which maybe I should say it, maybe I shouldn't, but I'm going to. There is nothing more fun in the practice of law to be arguing a case in the Court of Appeals, and they say, what about such and such a case? And you can say, that's my case, let me tell you all about it. That adds a level of persuasion that most lawyers don't have in these situations. So, and I know Mike runs into it too. I mean, there is nothing new. It just keeps happening over and over again. Maybe a slight variation, but there is nothing new under the sun.
So in the early 90s, you already touched, Jon, on one of the major changes, which was a much more detailed definition of what it means to be a public agency. You had these intergovernmental bodies, much more detail too around, to your point about the universities. You added the provision that says, any entity whose members are appointed by somebody who is a public agency or a public official. And we dealt with that here at Western and some other places around, cabinets for university presidents or sort of informal advisory committees. Are they public agencies, and how to deal with that? So I think you all were pretty prescient back then in identifying some of those types of, quote, informal groups. But you also added, and talk to me a little bit about how this came about, the provision that said An agency violates the open meetings law if it holds a series of meetings with less than a quorum of a board. So what prompted that?
That was prompted by the behavior of the Jefferson County School Board, as were many of the provisions in the open records law. Back then, there was a practice which goes on today of making sure that the superintendent would call in one by one each member of the board, go over what was going to be talked about at the board, get his or her approval, and then the board meeting would last about 12 minutes. There'd be 3 things approved, and off they go. And I talked about it as a Jefferson County School Board amendment. We hadn't really talked about that, but that was one of the big changes. And we have, in fact, won some cases on that theory. It takes a little proof, but you'd be surprised how easy it is to get proof once you get some people sitting down and talking about how important they are. So it's and as Mike knows, I mean, one of the fun things I have learned to really enjoy the fact gathering process of the practice of law, not just the media law, but the whole practice of law. I love facts. I had a mentor of mine when I was a very young lawyer say to me, when you're in law school, all the facts are there because the cases are printed. He said, now you got the hard part, you got to make the facts. Well, that's both the hard part and the best part, because when you can make the facts and you know where you're going and the other side doesn't, you're in great shape. And you've had that experience.
We're going to talk a little bit about that here in a few minutes, but I think that is absolutely right. And I guess just briefly before we leave those changes, you all also in the 92 changes, I think this merits special attention. You changed, you repealed and totally replaced the existing rules around special meetings and, importantly, Attorney General appeals and judicial review. This sort of blends open meetings, open records, because those changes in 92, affected both laws. But talk to us a little bit about what changed with the judicial review and Attorney General provisions and how that played together with the legal defense fund we have now and how that all comes together.
The Attorney General review is extremely important. In those days, we thought, inaccurately, that we would always get a fair read, that we would usually get a fair read from the Attorney General. Cameron, in the last 4 years, has proved us entirely wrong. Just as an aside, his opinions ignored the law. And not just skirted it, they ignored the law. He was set on taking the open records law, I think mostly open records, I would say.
Yes.
And abolishing it. And we've been very active. Mike has been more so than I in the last 4 years, very active on taking stuff that Cameron said going to court. What we added, I think we added this in 90 or 92, was that we added it, we were having a problem, and David will remember this, we were having a problem with getting an Attorney General's opinion. We've always had the Attorney General's opinion, Attorney General would get. But we would get a decision from the Attorney General that says XYZ agency violated the law, and the agency would say, so what? What are you going to do about it? So in 90, we put in a penalty provision, a pretty darn strong penalty provision, as it turns out. And a provision that says that if the agency, if the losing party does not appeal within 30 days, it becomes the law of the case. That is, and all you have to do to enforce it is to file a lawsuit saying we filed a complaint with the Attorney General. The Attorney General said X, they didn't appeal, so X is the case. The best case that we've had, and we had some others that are going to be good cases too, but the best case we had dealt with the abuse cases well, Todd County was the one but the abuse cases really arose, we had sued the Cabinet for Health and Family Services, and There was a terrible situation in Todd County involving a little girl, a 9-year-old girl, I believe, who had been abused and was ultimately killed. And clearly, her family had been under the supervision of the cabinet, and the Todd County, the newspaper filed an open records request asking for all public records. Public records, by the way, is a term of art in the statute. Asking for all public records relating to this young lady and how it was treated. And the cabinet came back and said, we don't have any records. We don't have any records. We waited 30 days. They didn't do any. Oh, excuse me. We then filed an appeal to the Attorney General. Actually, the newspaper did, with the help of the Kentucky Press hotline. Filed an appeal to the Attorney General, and the Attorney General issued an opinion that in essence said, you've got to have records. That cannot be the case. There got to be records. We're ruling against you, and you got to give up all the records. They did nothing. So I think literally on the 31st or 32nd or 33rd day after that decision, we filed a lawsuit. We already had what I call the big lawsuit going. So we filed a lawsuit and joined it with the big lawsuit that was filed by both the Courier Journal and the Herald Leader. And at the next hearing we had, unbeknownst, I didn't know this was going to happen, in front of Judge Shepard, the cabinet came in and they had a stack of papers, maybe 6 inches worth of papers, and they held it up and they said to Judge Shepard, we want you to look at all these records and tell us which ones we have to produce. I basically went nuts at that point. And Judge Shepard knows I occasionally can get hard-spoken, not soft-spoken. And what I said was, this is incredible, Judge. They had told us, and apparently lied to us when they said they had no records. They told the Attorney General they had no records. They reportedly lied to them. And now they're coming in with this 5 or 6 inches of paper, which I've never seen, and they're saying, take a look at it. Well, fine, take a look at it, but we're entitled to every piece of paper because of the law. Because the law says they didn't appeal, we're entitled to everything. And Judge Shepard, to his everlasting credit, took the weekend, read the whole thing, and put the entire record in the court record. So it was available to everybody in the state of Kentucky and elsewhere. That case, that particular case from Todd County, I think we used as Exhibit A on why we needed to get all of these abuse cases. Mike did part of the case with me toward the appellate part of it. And we ended up with a case that for the first time issued substantial penalties and legal fees. The Todd County standard got back all of its attorney's fees, which it hadn't paid, because I actually had called and said, you don't owe us anything until we, it sounded like one of the TV lawyers, I guess. You don't owe us anything unless we get paid. I could have done that. Anyway, and so we got our attorney's fees, which I think on the Todd County standard was something like $40,000. I mean, that's my recollection. But on the bigger case, in which the abuses by the Cabinet for Health and Family Services were many and very frustrating, the court awarded, I think in excess, attorney's fees and penalties in excess of $1.2 million or $1.3 million. There's an issue, by the way. There's a penalty in the open records law for $25 a day for each record. And so what counts as a record? We said each page. And I can remember talking to Mike about this. We figured out if we got that, we would have a bigger budget the next year than the state of Kentucky. It went into the several billions. We had a good time with that.
And the things never change. We have been having the same debate in our fight with the city of Louisville over the Explorer records, where they deleted 750,000 records of unknown number of pages, and it's been 5 years, and we figured out it was tens of billions of dollars in penalties should we be awarded.
All I know is I said I can call the governor and tell her we'll help with the pensions. It was a huge award, and I think we both argued at the Court of Appeals, and it was a fun argument because it was an easy argument. And there's some stories about that which I won't tell, but we had practiced the case from the beginning, and we used the Todd County standard cases. It's amazing. I got asked to testify at the legislature. We used Todd County. It was a great, horrible thing. I mean, this little girl had been killed by her. It's convoluted in terms of what he was, but I called him a stepbrother. And it was, and the cabinet just refused to talk to us, refused to talk to anybody about it. And I went at it with Governor Steve Beshear, who for some reason decided he was going to be against transparency, and tried to do several things about it, including starting a study group, or whatever you call it, a reporting group for that the cabinet had to report to about these abuse cases, but he wanted to close the entire process so that you couldn't get anything about that. We had, and we were very successful in getting the legislature to turn against the governor on that. So it's
those are now open meetings.
Those are all open, and their reports are open. Mm-hmm. Really important.
So we've sort of danced around this, but I just want to put a highlight on it. Talk a little bit about how the 92 changes to the open meetings and records law directly led to the Legal Defense Fund, and what you think that's meant for folks.
Well, I don't know that it directly led to it, but I will tell you that in having practiced and represented all of you guys for all this time, it's very hard to say 50 years, so all this time. I don't think there's any question that the existence of the Legal Defense Fund and the hotline have been extraordinarily important in the entire enforcement of not only media rights, but individual rights to get these records. For every case that we've had, there probably are dozens where we've answered a phone call, given some advice, and the records have been produced. For every case that we've had, one of the joys that I've had, and I know Mike has had too, is working with university students. I think we have a university press in Kentucky that is second to none, that is just terrific. Hard to convince people of that unless you've been here. But I will also tell you that we have a press association that's second to none. People tend not to believe it, but David will tell you how many times he gets a call from a press colleague from Nebraska or Georgia or someplace. What do you do about this? And David will say, well, we've had that in the law for the last 30 years. I mean, we've been way ahead, way ahead. It's because we've had a press association and newspapers that have been willing to put their money where their mouth is. It's been an extraordinary experience for us.
So let's talk about a couple of the more recent open meetings and open courts issues that we've had to take through the courts. One notable one, of course, with John Nelson and the Advocate Messenger against the city of Danville. There's another one where you made some great facts in the discovery process.
There are a couple of cases with Nelson that I'd like to talk about. That is one with a good result and one with not such a good result. There have been disappointments, obviously. The Danville, I'm going to get my name screwed up, but the city council was essentially authorized the purchase of a building in downtown Danville that was going up for an auction. It would be put up on an auction, a final auction. And they authorized the purchase of it, so that at the end of the auction, without a meeting, without any notice, not any discussion, not any public discussion, the city of Danville ended up owning a $5 million building. I believe it's a $5 million building in Danville. And we decided, John Nelson decided he wanted to challenge it, so we challenged it. And it was one of the things that I think we put in 90, but I'm not 100% sure, was the definition of action taken.
Mm-hmm. Yep.
Another little thing about action taken. Well, action taken doesn't necessarily mean a vote. It doesn't necessarily mean, it just means a commitment, however you get there. And clearly the city council, Danville had committed to buying a building without an open, without any meeting whatsoever. We had, I actually wrote a letter, something I've done once. This is the only time I've ever done it. I wrote a letter to the lawyer for the city council saying, here's what's going to happen. And we went through it. I mean, I went through it point by point, and that's what happened. It didn't take a genius. I mean, I'm pretty sure what was going to happen. But he fought and fought and fought. Well, we ended up winning that. We did not get attorney's fees, which we should have gotten, but we got everything but attorney's fees. And I think the remarkable thing about that case, it's amazing how often it happens, is that the building turned out to be a lemon. They didn't have any use for it. They ended up holding, was it $5 million, John? $5 million building, that if they had an open meeting, they might have had some people coming in and saying, why are you doing this? We don't need it. But they didn't do that. There's a lesson in politics there, a lesson in public policy. But they were determined to keep it secret.
Yeah, I was going to say on that case, it's the perfect example, I think, of why the procedures really matter, because when the new mayor took over, he wrote in the paper, an op-ed, and he said, you know, we're a government agency, so owning commercial real estate like this doesn't make sense because we don't have taxes to deduct. And he's like, and oh, by the way, it's going to cost multi-million-dollars to renovate this for the purpose we need it. He's like, if we would have had this debate in public, somebody could have pointed that out. But you're right, their attorneys were dug in because they had given them the advice it was okay to do this.
Right.
And
the real problem was that under our theory, which turned out to be the law, the city could not bid at this type of auction because it had to have approval of city council for the governing agency for the final purchase price, and that struck some people as being a problem. I mean, our answer was there are lots of things a public agency can't do that private people can do. And so we won the case, but I think that's why we lost the attorney's fees. Plus we have some very old-fashioned people in the Kentucky Supreme Court.
well, yes, that was true. And you know, bad facts, bad law kind of situation. But I think for the city, it didn't help that they not only had this secret meeting to decide, but then hired an agent to hide their involvement and kept everything clandestine. And it wasn't until they actually owned this thing that they said, guess what, that was us. I don't think that sat very well with the courts.
They also weren't getting great legal advice.
Well, that's true.
One of the members of the city council testified that they made a commitment to vote this way.
Yeah, we reached a consensus.
We reached
It's like,
a consensus.
that's what the law says action means.
If he had read the law, he used exactly the words that were used in the law to say they made a decision. Some cases are easier than others, and that was fun.